The Constitutional Court will hear the Electoral Commission's challenge of former President Jacob Zuma's eligibility to serve in the National Assembly on the 10th of May, just 19 days before elections. This is revealed in directions issued by the Apex Court on the matter. The Electoral Court recently upheld Zuma's appeal against the disqualification of his candidature in terms of Section 47 of 1E. The Specialist Court, in its reasoning, found that the Commission erred when it applied the said section to the former president, as Zuma's 15-month sentence was not appealable. The IEC has now turned to the ConCourt for finality on the matter, which will inform the current and future elections. For more on this, we're now joined by Mpumelelo Zikalala, a legal practitioner from Zikalala Attorneys, and he joins us now via our video link. Mpumelelo, thank you so much for joining us here on SABC News. I mean, just looking at the directive from the Constitutional Court today, this matter will be heard on the 10th of May, and it's just 19 days before we go to the polls. Is the court not cutting this too fine?
We must give all the interested parties.
Sorry, you can go ahead.
The court was saying we must give all the interested parties enough time for them to place what they need to place on paper, to come and argue before us before the 29th of May. So what the next obligation would be, after the 10th of May, the matter has been heard, the court must give itself maybe 36 hours to come back with the ruling, because that's going to be very crucial. It would depend on whether the name of the former president appears in the ballot paper or not. But I think what the court has done now is to say, as the applicant, IEC, we're giving you enough space for you to be heard. As the respondent, we're also giving you enough time, former president and also the MK party, to come back and give us the submissions that we should concentrate upon. And we are going to adjudicate this matter as quickly as we can, so that we do not close the door on anyone that wants to exercise their rights per the Constitution.
And it takes me back to when we saw this judgment from the Electoral Court, and the reasons which were given by the IEC for taking this matter on appeal to the highest court in the land was based on the fact that they wanted to find out on what grounds did the Electoral Court allow for former President Jacob Zuma to participate in these elections and then head on over to the National Assembly. One would ask, now that we've seen the reasonings or the reasons for this move by the Electoral Court on Friday, is it still necessary to have this appeal?
I would have thought that by this time, maybe the IEC would have said, well, you've looked at the reasons. Out of all the three reasons that are there, even though they're different, but they always lead to the same conclusion of saying that the name of the former president must form part of the ballot. Maybe they would have reconsidered and say, you are no longer taking this matter to the ConCourt. But it seems as if they are bent or hell-bent on taking it to the ConCourt in order to defend the decision that they've taken, even though there are some reasons which are cogent enough or that are reasonable in terms of why the court arrived at a particular reason, especially the one of saying, you have two instruments which are at play here. You have the judiciary that has the power to issue out court orders and issue out sentences, but most importantly, we also have the Constitution, which is the supreme law that has given the president powers to remit sentences. So if it has been allowed by the Constitution, although it is an abnormality or an exception to the rule, the mere fact it is allowed by the Constitution, and the Constitution says, Mr. President, we have power to bring down the sentences which have not been given out by you or that did not fall within your realm. I would have thought maybe the IEC would have accepted that particular ruling and said, okay, we have been told by a court of law that this is interpretation that they have adopted. Let's adopt the same. We'll learn that moving on as to how to deal with this type of instances moving forward. The other problem that I would have found, or in the IEC judgment itself, is the one that says it seems to have missed a very important point of giving an opportunity to respond to the former president before a final decision is taken. One would have expected that once an objection has been filed, you take it back to the individual that has been complained about, and you say to them, here's an objection which is detailing something about you. What do you have to respond about before we take a final decision? There may be a procedural flaw there that I think might need to be traversed and maybe be later determined by the Constitutional Court. But coming back to a question, I would have thought maybe the IEC would have said, well, you accept the reasons which have been provided by the Electoral Court. Let's let the matter rest. Let's continue with watching over the elections and making sure that we deliver them on the 29th of May.
And what room now does the IEC have now that we've seen the reasons from the Electoral Court on Friday, and now that they will be bringing this matter on the 10th of May, what room do they have now to argue in court?
I think they may supplement their papers, because remember that the papers were submitted without the reasoning which comes from the court. So when you want to take the matter to the Constitutional Court, the first point of call is to say, this is why we think that the Electoral Court was wrong. This is what we are basing our arguments on. So let's submit fresh papers. Of course, the submission of those fresh papers then means the former president and also the MPM party must then be given another opportunity or time in order to look through those and be able to respond in their answering affidavit. But it does give a bit of light and makes the arguments which are now going to be issued by the IEC much more cogent and much more direct and much more specific to what exactly their issue is with the judgment that was issued. But the minute that happens, you also have to give the other party an opportunity. And I think what the Constitutional Court has done today is to lay out the groundwork and the rules in terms of saying, this is how the timelines are going to apply. Make sure that every interested party must be able to comply, so that on the 10th of May, we hear the matter, and probably within a few weeks, a few days from then final judgment will be issued by the Constitutional Court.
And, you know, looking at the climate in which we find ourselves in, I mean, we are just a few days away from the elections. Elections will be held on the 29th of May. Can this be deemed as a political move as well, coming from the IEC? Because we've seen this judgment from the Electoral Court that has okayed former President Jacob Zuma to participate in these elections and, you know, to go to the National Assembly should his party be voted in during these elections. Can one still say that, you know, it seems as if the IEC is targeting former President Jacob Zuma?
Not necessarily so. Remember that the IEC has got a very important obligation of making sure that it runs credible elections. And if it so believes that something is going to change that credibility, it has the right to go to the IEC and say to any court of law and say, you as presiding officers have been given a duty to adjudicate. Here's our argument, come back and tell us whether we are correct or we are incorrect, and then we'll take it from there. So the exercising of power of going to any court is something which is the prerogative of any government or state entity, including the IEC, and they should do so if they so believe strongly in their case. But I think the most important point, which was also lamented by the judgment, was to say, when you look at Section 19, it is a very important right that you do not want to play around with. So you would rather err on the side of caution by allowing, even if that one individual is not supposed to be on that National Assembly according to your beliefs, but for the sake of making sure that you want to protect that important right, which is Section 19, allow the individual to participate, allow all the processes to be there. But again, there's nothing stopping you from going to any court of law in order to come back with a determination to say, what is the correct position when it comes to these type of things? If we're ever faced with a similar situation 2 years down the line when we go to local elections, how should we interpret or how should we deal with it? I think from the IEC, that's the point in which they're coming at.
And how quickly can we expect the Constitutional Court to actually deal with this matter, considering the timing of the hearing of this case?
It should be very quick, taking into account that ballot papers need to be printed. Taking into account that after the 29th of May, there's only a short amount of time that will be available. I think it's 14 days up until the National Assembly is able to sit. So it's very important for individuals for this matter to be done and dusted even before we go out to vote, because that's when the list is going to come out. So if the list is locked by the time we go and vote, there's nothing that can be done or can be changed afterwards. It then means for the Constitutional Court is going to be one of those matters where they have to bring out judgment as soon as possible. It is an urgent matter, and once it is deemed as an urgent matter, it then says even judgment on that urgent matter, including the reasoning which are yet to follow, must be done within the shortest space of time. So I do suspect that maybe a 36, 48-hour time period will lapse up until judgment is issued on that matter, even if we do not get the full judgment as to the reasoning behind why I arrived at that conclusion, but at least some determination as to who was won and who was lost.
Mpumelelo, always a pleasure talking to you here on SABC News. Thank you so much for your time. That is Mpumelelo Zikalala from Zikalala Attorneys. He is a legal practitioner, just giving us his insight there in terms of that matter, which will be heard by the Constitutional Court on the 10th of May. And we understand those court documents need to be all filed by Tuesday this week.